At a trial, a judge may address the jury at certain times. What are those situations where a judge might address the jury?
Well, Dinesh, the judge can address the jury during the trial on certain findings. For example, if certain things are found during cross-examination and they're asked to be disregarded in other hearings, then the judge can then tell the jury, no, don't worry about this piece of evidence, or disregard this aspect of this piece of evidence. So that's one example of what the judge can say to the jury.
Dinesh, I guess once cross-examination is over, there's also potential for re-examination, which is generally, I guess you would say, a second examination of the witness that was called by the party that called them. And I'll ask further questions about what the witness has said during cross-examination before they go into their final address.
Now, finishing off a trial, what are the final things? Is there a final address, and how does people do that?
There is a final address. The Crown summarises their case, and the defence also summarise their case and essentially make an argument for the jury as to why their client is innocent. It's the sort of exciting part that you see in Boston Legal or American movies. That's the part that's always shown, because it's the final argument before the jury is directed by the judge and go on to consider their verdict.
Right. Then the last part, the sentencing. Yeah. So what does a judge take into account when sentencing? Probably Harlis also can add after.
Yeah. Well, the sentencing is also a very important part of it is perhaps one of the most important part of the process, and
because the accused get to know.
Yeah, exactly. We'll get to know
they
how
will
many...
have been found guilty by that stage if they're being sentenced.
Exactly. So things like the background of the accused, whether there's history, whether there's priors, those things are all taken into account. The severity of the offending, the remorse of the individual, and also another thing that's taken into account is sentencing discounts. For example, plea of guilty and plea of not guilty. Obviously, after trial, there will be no sentencing discount in terms of that. It's 6AAA of the Sentencing Act. There will be no discount if you choose to go the whole way and conduct a trial and you're found guilty.
As a barrister who represents clients, and you're probably put into the same position, and when you're representing, what do you do? What do you have to add to this conversation?
That question about what does a judge consider is a very complex question. You could write an entire book about that question, and people have written entire books about that question.
That's what we study for 8 years.
That's right. It's it's a real question of. There are lists of dozens and dozens of things which have created controversy. For example, if someone was drunk or on drugs when they were committing the offence, does that make their conduct worse, or does it make it better? These are the sorts of questions that cause controversy, aren't necessarily resolved. New South Wales and Victoria take somewhat different approaches. So it's a very complex question, and sentencing is really a stage in which the art of advocacy probably comes out more than anything, because the jury is not involved. Not because the jury is not involved. It is true that the jury is not involved, but it's a very fluid process. Yes.
And there could be a million things that would affect a way a judge or a magistrate sentences, and the spectrum is huge.
That's all the time we've got for you today. I'd like to thank the panel. If you want to catch up on our past episodes, you can go to our website www.lawhelpaustralia.org, or you can do a search on our YouTube channel or on Facebook. Just search for Lawhelp Australia. If you want to ask a question, or if you want to join a panel, email us on info@lawhelpaustralia.org. Bye for now.